Check out what the satisfied Dan Gemus real estate team clients are saying about working with the Dan Gemus team. Visit dangemus.com.
I got to thank you for being a voice of reason in a sea of insanity.
Now back to the Dan Gemus Real Estate Show on AM 800.
Okay, everyone, welcome back to the show. Kathy Talbot in studio with me here, and it's time for our legal segment with Christian Janisse from SimplyClose. Hey, Christian, how are you?
Not bad. No complaints. How about both of you?
Well, we're fantastic. Thank you. It's a hot weekend, and we're ready for some. I am ready for it to cool down. Kath wants to keep the heat coming a bit longer. So,
I'm with Kath.
Oh, you're with Kath.
I'm with Kath. Yeah.
Oh boy, Kath. There you go. You're not alone.
That's good to know.
Yeah. Okay, perfect. So, Christian, you have an interesting topic today for us. What do you got?
Yeah. So I started doing this newsletter called Clause in Effect, and this one was kind of popular. Basically, the story is pretty simple. We have a couple, boyfriend and girlfriend at the time. Mm-hmm. They bought a house together, and that's important because one person didn't already own the house. They bought it together. Okay. In 2008. They basically lived there for 10 years. They had 3 kids, and only one person was on title, though.
Okay.
So boyfriend goes on title. Girlfriend lives there, raises the 3 kids, contributes to the household both by taking care of the kids and doing other domestic chores and also working and contributing financially to the house.
Okay.
And then they separate 10 years later. And he claims she doesn't have anything in the property. She's not on title. And the general rule is that a common law partner doesn't have any rights to the property. But the argument that she put forward was that she did have rights, that he was holding the property essentially like in trust for her. Although she wasn't on the title to the property, she contributed. It was always the intention that they would own it together, and that she would benefit from the house because she didn't buy another house. She couldn't have bought another house. And in fact, she was contributing to this house. And so she said, we were pooling our money at the time. I contributed to the house, and it would be unfair, or the word is unjust enrichment. In other words, he would benefit to her detriment because of all of the contributions that she made. Sure. If she didn't get anything. He argued, the mortgage was in his name. He did all the major repairs. He never asked her for any money. And in fact, if she is owed something, the house hasn't been sold. It's still owned by him. So she shouldn't get anything until it's sold by him at some point in the future. Her contributions were just ordinary household expenses, almost like roommates. They weren't actual investments in the property. And so the judge actually didn't side with him. They sided with the girlfriend and said that, sure, she gets half the house. And that was $191,000 was the increased equity, which they obviously got an appraisal and things like that. And one thing that was interesting was that they said household work and childcare provided by her freed up his time so that he could go earn an income and increase the household contributions financially and increase the value of the home in order to pay for those renovations, in order to pay for those major investments that he said weren't major investments. He was only able to do that because she was taking care of the kids. And I thought it was pretty interesting decision. And
listen,
it's not unreasonable.
Anybody who has kids knows that is completely true.
Yeah.
And, many people would prefer to go out to work than to be at home raising the kids, right? So that's often harder work than our actual jobs, right? So, I'm not surprised. Kath?
Christian, I found it interesting that the judge said, or the letter said, that had he done that certain paperwork, with some kind of an agreement between them or something like that, had they done that, he would have saved himself all that money.
Yeah. Yeah, because it's called a cohabitation agreement. It's basically like a domestic contract. Okay. So you can get one like a marriage contract, a prenup, postnup, or a cohabitation agreement. So if you have two people buying a house together, if one person's on title, even though the general rule is that the other person doesn't get a claim to the house because they're not on title, they can make what's called this trust argument, basically that, I'm not on title, but I've done things to this house for your benefit. So even if it doesn't even have to be like boyfriend and girlfriend, even if Dan and I bought a house, we were friends, we're roommates, we're going to live there, and we said, oh, you know what, we're going to split all the costs 50-50. Mm-hmm. If we don't have an agreement signed, I can make an argument to say, I'm the one that paid for that fence, and that fence increased the value of the house by $10,000. So even if you have a tenant that's contributing to your property, obviously they're not going to contribute enough to bring a claim, but anybody can make that claim. Like if I go to Dan's house and lay the floor down and he tells me to lay the floor down and then doesn't pay me, I can make a claim for that and say I did that work. And that's essentially what she was doing, was saying that, you know, although on paper she wasn't listed as an owner, she gets the rights through, you know, having contributed indirectly. And so if they would have had an agreement, they could have laid all that out and said it's not the intention for her to have any part of the equity of the house.
Now, Christian, let's talk about spousal consent on this topic then. What point would that have taken effect or not taken effect?
So they wouldn't have needed spousal consent to sell the house or to get a new mortgage, because that's if you're legally married. But once it was sold, she could still bring that claim afterwards and say that he got all that money. So, but if they would have signed a contract, you can sign away your rights as a common law partner, at least, that, you know, hey, I am recognizing that I'm just living here. It's not an expectation that I contribute to the house, or it's, you know, my expectation is that I'm going to pay for groceries, but things like that, to basically set it out all on paper.
So for listeners who are not familiar, Christian, let's go back to the basics of spousal consent. What is it, and why should someone pay attention to this?
So if you are legally married, then, and you have one person that's not on title, and it's the matrimonial home. So if you have like a rental property and it's not where you live, then if one person's on title and the other's not, you don't need spousal consent. But for the matrimonial home and you're legally married, you can't sell or get a mortgage on that property if the other person's not on title without their consent. And the reason for that is that the person that's not on title, by being married through the Family Law Act, gets rights to that house indirectly, no matter what. Like, that's in law.
Yeah, and so this does not count. You have to be married. You have to actually be married, correct?
Yes, yes. And that the point of that is so that, you know, if you have a nasty divorce, which I think most of them are, the one person who's on title can't turn around and go take out all that equity by way of a mortgage, siphon all the money, and then by the time it does get through the family law or like proceedings in the court, well, great, you won on paper, but the money's already gone.
It's true.
Because they went and took a mortgage. So that's why you need the spousal consent. And I've had situations where people have tried to sell the house without spousal consent. You can get a court order to do that, but it's very difficult for the court to basically sign off. The person almost has to be like gone, missing. Can't find them, which is what we had to deal with. Well, that's what we had to deal with. The guy went missing.
Wow.
Really?
Yeah, they couldn't find him. So she got a court order. No, wow. I didn't know. The money's sitting in court, basically waiting for him. But she couldn't afford the mortgage on her own.
Sure.
So she wanted to sell the house. Otherwise, it was just going to get worse and worse and worse. So she got a court order to sell the house without his permission.
So the money's sitting in trust?
Yeah.
Forever? As long as they don't find him?
I don't know what the rules are for that part. They had family lawyers, and I steer very far away from family law for obvious reasons.
Oh, my goodness. Listen, do you have time for a couple of listener questions?
Yeah.
Someone says, can a deal fall through because mistakes... can a deal fall through because mistakes on paperwork? Can a deal fall through because mistakes on paperwork? I'm not sure what mistakes. Yeah.
It would depend on... So just not necessarily real estate, but just general contract law. If... You have to have meeting of the minds. So that's offer, acceptance, consideration, which the ORIA form automatically has all of those. Mm-hmm. You have the offer, it's then accepted, and then the consideration is like the purchase price. So if there's a mistake on there, it generally doesn't fall through unless both parties recognize that that was a mistake. So
I'm trying to think of what kind of mistake there could be. Like maybe a closing date maybe had 2024 as opposed to 25 or something like that. Maybe I'm trying to imagine what mistake could happen.
Yeah.
Spelling mistake on a name or something?
I can think of one. There was, I forget. I think I forget what the mistake was, but the person, you know what it was? I remember Joyce asked me about this like 4 years ago. They changed the purchase price, but the person who like got the amended contract back didn't realize that the purchase price changed and just signed anyways.
Oh,
and then later said, oh, like that was a mistake. We didn't mean to sign off on that. And in that case, I don't think the deal would fall through. If there's a mistake for like a date or something like that, I also don't think that the deal would fall through. It would have to be like a mistake that basically would render the contract frustrated.
If you write a contract, write an offer on, last month, but the closing date is a year ago, well, clearly, that's
It's just a mistake.
it's a mistake. Yeah, clearly.
Yeah, and I would say that it would be like the courts would say that common understanding was that you clearly meant for it to be at this time.
Sure.
But yeah, no, they wouldn't necessarily fall through on a mistake unless it can be proved that it was like a mistake that was, I can't even think of it. No, not really. Yeah. You have to review the contract.
Yeah, for sure. And the other question is, does a buyer always get the deposit back? So I'm assuming if a deal falls apart is what they would be asking there.
So it depends on if it's in the conditional period or not. So generally the conditions say that the conditions included for the buyer's benefit, and if it's not satisfied or waived within a certain period of time, the deposit can be returned in full to the buyer. Now, the thing about that is that the condition actually has to be attempted to have been fulfilled. So in other words, you can't put a condition for financing as the buyer and then just say, okay, I'm going to put that in there, never search for financing, and then 5 days later say, oh, you know what, I actually found another property for a better deal.
Right.
I'm out. In that case, you wouldn't get it because you're acting in bad faith and you didn't actually attempt to fulfill the condition.
Gotcha. Yeah.
If it's after the condition, so you have like the firm offer where the conditions are either satisfied, waived, or there were no conditions in the first place, then the buyer doesn't always get it back just because the deal falls through, because the seller generally gets to keep it, even if they sell the house for more, because it's viewed as, you forfeited that. That was your security towards performing the contract, unless the buyer is not the reason why the deal fell through. So if the seller just has cold feet after it's firm, then yeah, the buyer would get it back, but they'd have to go to court to get it.
Gotcha.
Unless they sign a mutual release.
Awesome. Great tips today. If someone has questions, what's the best way to reach out to the Simply Close team?
They can email us at hello@simplyclose.ca or call us at 519-997-3775.
Fantastic. Christian Janisse, thank you so much. As always, we'll chat with you in a couple weeks.
Yeah.
You got
Take
it.
care.
Thanks. Bye.
Bye.
That's Christian Janisse, a real estate lawyer with Simply Close. So great tips there. And interesting stuff, Kath. So we're going to take a break. We're going to come back with some listener questions. We got lots of those coming up. We'll also give away the gift card for the Richmond Popcorn Company. Lots more to come right here on the Dan Gemus Real Estate Show.